and you understand it. So you want me to do direct and evidence, and you're going to do cross?
No, you do direct and
evidence
impeachment.
And objections.
No, I'll do cross objections, and then you do direct, impeachment, and recollection, because impeachment's arguably like the biggest thing here.
Can you put this here? You just make this go away, make a space.
No. There we go. Is that fine?
Yeah. It's fine. You know it's F5 to start it?
I do.
Okay, but I'm gonna speak to them.
Oh, beautiful.
Yeah, you're gonna not speak to them. Can you?
Yeah, I know. I got the code too, but apparently the people also had to order it in an order. Right? I know. She told me that yesterday. No, because why would you?
No, and they were like, sorry for the backlog. Very creepy. Every time you try to
Yes. So it's more.
How did you get tickets?
Yesterday, so I got tickets for about 3 times, and I got pizza and didn't use it. And then I went yesterday after meals and like class, and I got I know, I was like, that's not what
Obviously, don't do damning stuff.
Is this yours? No? I don't need drugs.
spend 60 minutes on that. Like, the opening will just be like, we're gonna win this. First witness. But it's like every restaurant we meet on, we're gonna rest like 3 episodes.
Yeah, we just use it for this guy.
Yeah, that's what I'm telling you.
If you're gonna announce at the end, okay. Yeah. Oh, that worked. Cool.
Hi y'all. Welcome to the second tip session. Before training chairs get started, I just have like 2 quick announcements. Number 1, someone pointed out, because they're really good readers, that the email from Alex is signed RP. That's just like a mistake. That's not like a ooh thing to catch. So it should be it should be AD. Like, don't harp on that. Like, that was my bad. Blame me. And then the second thing, so we also gave you conflicting information about the order in which closings happen. The rules are wrong that we sent you guys. What happened in the tip session last week are what's right, and I'll answer this in the Q&A. I think someone put in the Q&A as well. So the order for closing is going to be claimant, and then respondent, and then claimant will have the chance to rebuttal, which is what they explained last week. Yes?
Is claimant first for questioning too? Like, does the claimant's witness go first?
Yes.
So they're always first.
Yeah, they're first for opening, first questions, and...
Except for when the respondent presents their case, the respondent, when like that part of the arbitration starts, gets to present their witness first. That makes sense, yeah. The respondent gets to present their witness when we get to the respondent side of the case. Like, we do the claimant's case first, but respondent's witness.
The respondent still has opening right after.
Yeah.
Oh, okay.
No, I'm not conflicting that. I'm just saying, like, usually take a break, right? And then like people would be like, oh, it's the claimant's turn, it's the respondent's turn.
Yeah.
Okay. All right, hi everyone. My name's Ariel again from last week. This is Aaron, and I'm gonna lead you through a few things, but we'll go ahead and do a brief review of the components of arbitration. We're gonna talk about direct examination, cross-examination, making objections, and what goes along with that is offering evidence. And then we're gonna have a demonstration that will include all of those things. And then we'll have a Q&A, but if at any point before then you have questions, feel free to ask them as we go along. So, just to review a little bit, there's housekeeping matters, which we talked about last week. Those are just questions that you'd like to clarify to the arbitrator beforehand and just kind of start talking in the round and get yourself comfortable. Then there are opening statements. First the claimant goes, then the respondent. Then the plaintiff will present their case in chief. They will do their direct examination of their first witness, and then the defense will cross-examine that witness. Then the claimant will have their second witness be directed, and then the respondent will get to cross them. Then it's the defense's or the claimant's side, or the respondent's side, to present their case in chief. They have their direct examination, and then it's just the opposite. The claimant gets to cross-examine. So finally, you'll have closing statements. It's again the claimant, then the respondent, and then the claimant will have their rebuttal. So that's what we talked about last week, but just a little review. So this week's new information is, one of them is the direct examination. So the direct examination is when you're asking questions of your own witness, of somebody who's going to help you prove your arguments. And the way that you want to do this is that it's about the witness. It's not about you. You want to make sure that they're telling their story, and you're just kind of there to help them answer questions in a way that tells that story. So it's not about having really long questions. It's not about trying to tell the story for them. That's what the witness is supposed to do. So you want to think about the most logical way to tell your story. And like we talked about last week, there are some strategies for that. You could do chronological order. You could go by element of the law that you have to prove. So if you have to prove that there was a contract and then that somebody breached it, you might want to go in that order with your questions. But you just want to think about what you think is the best way to do that. And if you don't know, I think chronologically is always the easiest. You could just start with, how did this dispute start, and go from there. So you also want to signal to not only the witness, but also to everybody else in the room when you're moving from one topic of conversation to the next by signposting. So if we've talked about how the dispute started, I could say something like, so now that we've talked about why this dispute began, I'd like to talk a little bit about how you've suffered. And so that signals to everybody, we're done talking about the first part, and now I'm going to ask a line of questioning about the damages. And that's what it means to signpost and also to lay foundation for the upcoming testimony. And then we're going to talk about evidence, but with every witness, you want to think about if there's any documents that you want somebody to be able to see, and that somebody is the arbiter, but not every document needs to be entered into evidence. Sometimes you could just ask someone something like, what date was the contract? And if the CEO of the company says it was April 1st, 2019, that might be enough. But if there's like a real dispute about when the contract was started and the other side has a witness that says, no, the contract began on March 1st, 2019, then you might want to introduce a piece of evidence, a document corroborating what your witness said. So sometimes people like to enter a lot of evidence. Some people like to enter no evidence. I think there's probably a happy medium, but it's really a judgment call. So just some technical things about a direct examination. So first, you must ask non-leading questions. And a non-leading question means that the answer can't be implied in the question. So I can't say it's true that the contract or the dispute began on March 1st, 2019, because the question sounds like the answer is it began on March 1st, 2019. I have to ask something more generic, like what day did the contract start? And that way, there's no indication in the question what the answer would be. And if you are the opposing counsel, you're allowed to object if they ask a leading question, because it's kind of seen as coaching the witness. So instead of asking your witness to know when the contract started, you're guiding them through it. You're like, wasn't the contract started on March 1st, right? So it's not, that's kind of seen as improper, and lawyers aren't supposed to get the testimony. Yeah.
What about a question that could sound leading, but you actually want cleared up? You could say, could this have been reasonable?
You can ask, do you think this is reasonable? That'll be the arbiter's call, right? If the other side objects to leading. I think some questions are a lot more leading than others. It's usually you can tell when you hear it, because there's some fact in there that they're obviously trying to prove is true. But if you can always rephrase your question, right? So if the arbiter says objection sustained, that was leading, you could ask something maybe a little bit more broad, and then your witness would know that you're trying to see if they could talk about the reasonability of something.
That's another thing. Do we get points taken off if we're successfully objected to?
No, you will not go through an arbitration probably without being successfully objected to, in the same way that once you're the person objecting, you will have some of them sustained and some of them overruled, right? There's no way that a judge is going to do 100% for one side, unless one side is just really asking leading question after leading question after leading question and asking those types of objectionable questions. So don't take a judge or an arbiter ruling for or against you more times than the other side as points off or points gained. It's really just, how do you answer the question, and were you noticing when the other side was doing objectionable things?
Can I chime in?
Yep.
You can get points though if you successfully rebut an objection. So if someone objects and you can fight it or whatever, and you do that well, that's an opportunity to earn. Right.
So I guess the point I'm trying to make is that you're graded holistically, right? So if the other side makes a good argument and you respond with a good argument, but the arbiter still rules in favor of the other side, you can still do very well scoring wise in the objection category because you had a good response. It just happened that they happened to vote for the other side on that objection. And sometimes judges will rule for the other side, not because they think that the argument is more true, but just like maybe they've been granting too many of yours and they want to just see how you react to an objection not going your way. Can you rephrase the question? So I really don't take it as evidence of like you're doing poor or doing really well. So the other thing, like I was saying with direct examination and telling a story, is you just want to ask like simple, short, common sense questions. You don't need to be really specific about it. You don't have to be like, what's your name? Where did you go to school? Why are you here? Like, you don't have to be like super nitpicky. You could be like, could you tell me a little bit about your background? And then they can go into talking about that. You do want to tell us who the witness is. It kind of sounds maybe irrelevant, like it's a contract dispute, but why do I need to know like who they are, how long they've been doing this, how long they've worked for the company. Those facts, though, are actually really helpful to like understanding the witness and personalizing them and getting some more context for why they might have experience or expertise in a field or why their testimony is relevant anyway. So do ask them a little bit about their background. Just don't, go overboard. And then you really want it to be conversational. This is your witness that you're bringing, and so you never want to fight with them. You want to be really nice and cordial, and we're going to talk about what happens like if they forget something or they say something wrong. But the whole time, even if that happens, you just want to remember that they're supposed to be helping you, and you don't want to look frustrated at any point. And they should be doing like 80% of the talking, and you should be doing like 20% of the talking. So these are just a few other things. Witnesses are great to explain complicated things or like there's like a dispute in the record. Once you've built up their background and how they know about this case and their involvement, then it's really nice when they could just be like, nope, that didn't happen. Or like, I know this seems complicated, but I was there and this is exactly what happened during that dispute. So that's something really helpful that they could do. And then, like we talked about last week as well, you want to listen to whatever the person who's talking is saying. But if they're your witness and they're kind of going like off script, so if you've prepared a script for them and, they're like going in a different order, you don't want to like make them come back to your order. You just kind of want to follow the natural way that it's going. So if you say, how are you involved in this dispute? And they start talking about the third meeting and you wanted them to start with the first meeting, let them talk about the third meeting. And then you could be like, well, how does that relate to what happened today? And you could be like, and then the witness could say, oh, well, there's actually a dispute about the first meeting. So again, this goes back to them leading the way and tying the narrative. But a lot of times what happens is, people make a script and then the witness doesn't follow it and they try to hint at what was in the script to get the witness to remember. So they're like, do you remember what happened in the first meeting on March 1st? And the witness is like, no, not like, no, but I remember what happened in the third meeting. And then they talk about it. And the attorney is like, no, do you remember what happened in the first? And like, they really try to like get them back on the message of the script, and it looks like you don't know how to adapt and that you don't know what your witness is supposed to say. And then finally, we talked about this strategy, but it might be wise if there's a bad fact for you to let your witness kind of explain it away. So if your witness happened to know the claimant, you're the respondent, and they happen to have gone to school with or know the claimant from a previous experience, it might be a good idea to ask them, do you know anybody in this arbitration? And to let them just say, yeah, I knew the claimant, we went to school together, but that's pretty much all the involvement I have. Because if you never ask that question, then on cross-examination, the attorney's gonna be like, well, you have a conflict of interest. You knew the claimant in this case, right? And they're gonna have to say yes, because they can't lie. And then it just kind of looks a little bit like, why were you hiding that? So if there's a bad fact, I'm not saying you should do this with every bad fact, but if there's a bad fact that your witness can give a common sense explanation to, it's a great idea to let them do that. And like I said, the witnesses are the star. Some ideas for coaching your witness, I think we talked about it a little bit last week too, but you want your witness to have read through whatever they have to know, but And you can make like a general script or outline, but the witness, it's like they're not going to memorize it word for word, and you're not going to memorize it word for word. So you need them to just understand what their utility is in the arbitration. Are they going to damages? Is that what they're here to talk about? If they're the wife of the claimant who suffered some big car accident and they're here to talk about, how the person, couldn't walk anymore and they had to perform a lot of chores in the home. You don't need them to talk about other things, and you don't need them to go in an exact order, right? They don't have to start with like chores and then health and then the doctor's bills. They could start doctor's bills, then chores, then health, right? So they just have to know what their utility is, and then it makes everyone's job a lot easier. Yeah, I see a question.
If we coach our witness in a way that like makes them like really into their character and they're like super sympathetic to us, and like in their I guess in their cross, if they are answering questions kind of like sassy or like hostile, will we get points off for that?
So this is all like a style call, right? So an arbitration is not a trial. And in trials and like what you see on TV, witnesses are sometimes very hostile. And even when they're hostile, though, sometimes it's not effective, right? Like it would just be easier for everybody if you could answer simply, even if you defiantly disagree that something happened, right? You could imagine like a murder trial. No one's going to get up there on a cross-examination, be like, yeah, I actually did murder him, right? So it's a little bit of a style call. I think you can encourage witnesses to like politely disagree, and we're going to demonstrate a little bit what that would look like. But I understand what you're saying. It's fine to politely disagree, but I think especially in an arbitration, if it gets kind of hostile, it just like throws off the balance of the whole room. So. And I just don't think like this prompt should like rise to the level of your witness needing to get very, very hostile. So I would also keep that in mind.
Yeah, I think you should just have your witnesses kind of use the facts in the best light for them. So if there's a little dispute between a phone call, for example, between Ryan and Alex, and you're crossing Alex or you're crossing Ryan, and that witness is hostile, that's okay. That witness should be a little hostile because they remembered it differently. So they should just use the facts in the light most favorable to them.
Right, but they don't have to be like, I was there and the other person is 100% lying. Like they could just be like, I was on the phone call and this is what I remember, and I'm telling you today what I can remember, and this is what I honestly think happened. And that's very different from like putting it on somebody else and saying that somebody's lying versus like, this is my own interpretation of what I think happened. And then also with your witnesses, you want to practice like maybe with your partner or with your coach getting objected to, because witnesses sometimes don't understand like they have to stop talking when there's an objection. Right, like I asked you a question, isn't it true the other day that you went to the grocery store? Objection leading. Like sometimes witnesses just start talking, and you want to make sure that if they hear an objection to just stop talking for a minute. And that's something that like we might know as law students, but if you have like a non-law student witness, these are just little things to remind them. We're going to talk about impeachment and refreshing your witness's recollection, but you're going to want to go over this with them in case it happens. People forget things, people misstate things, and they like completely forget the date. So you want to make sure that you know how to do these. And then also practice crossing your witness, right? Like you've written a direct, but you also know the reasons why your witness might have some like holes in their argument. You know what the other side should be able to say. So you should just practice going through a few of the hard questions with them that is in their testimony. Are you doing this one? Okay. Aaron's going to talk about offering evidence.
All right. Also, make sure your witnesses don't object for you on the stand. Like that's something sassy they should not be doing. Like they should not say like, hey, that's not relevant, or hey, that's speculative. Witnesses shouldn't be doing that.
I've never seen that.
Yeah. So when you're offering an evidence, you're essentially, what happens when you offer an evidence, you take a document, for example, the cancellation agreement or the cancellation policy, and you're trying to bring it into evidence so that the arbiters can see, so that other opposing counsel can see, and so that the witness can see, and so that it's on the record. So when you're entering an evidence, the first thing you have to do is make sure that it's kind of logical where you're going. So like if you're talking about, for example, Ryan's background, and then you just throw in the cancellation policy, it's just going to seem a little weird and misplaced. So when you start getting to the cancellation policy, and when you're directing Ryan or when you're directing Alex, you can say something like, and Alex or Ryan, have you ever seen a cancellation policy before? Do you know what this looks like? And then the witness will say yes, and then you essentially say, now Ryan, here's what I'm showing you. It's a cancellation policy at this time. You're also going to give a copy to opposing counsel. You're going to give a copy to the arbiter, and you're going to essentially ask maybe 1 or 2 questions about the document itself. Something like, do you know what this is, or what have I just given you? And then kind of like, what is it? And that's sufficient foundation to bring it in. At that point, you can kind of just tell the arbiter and just say, Madam Arbiter, at this time, the claimant would like to move in Claimant's Exhibit 1, which is the cancellation agreement. If you're the respondent at that time, you have the opportunity to object. Sometimes the arbiter won't even look at you and just say, hey, do you have an objection? So if you have an objection, speak up. But especially in arbitration, and especially because you guys have such a close field of objections, many of the exhibits are not going to be objectionable. Especially things like the cancellation agreement. There's really not much you can object on. But if you do want to object, go ahead and do it. If you think that you haven't objected enough or whatever. Go ahead.
If the other side already presented it into evidence, you don't need to do it again, right?
No. So if the other side has already brought it into evidence and you want to say give it to your witness so that they can read off of it or something, you can just say, now I'm going to show you Respondents 1, the cancellation agreement. And then you could even say, like, do you know what this is? And lay a similar foundation, but you don't have to enter it in again.
How does the logistics of like giving the piece of paper like, do you stand up and give it, or you pass it around?
It's really whatever is natural. You can stand up if you want, if it's really far away, but you don't want to move to the other side. You can just
You do.
you stand.
No, you give it to them.
You can just pass it.
No, but
No,
so I was
you stand up and then you like.
It
I
depends
was
what.
in a small room last time.
Yeah,
and
it depends on the size of the room. But if it's a big room and it's like LLC 6, if you guys have ever been in there, then stand up and walk around. But if it's like a small room, like and you guys are just sitting on a small table, just hand it.
Should we just ask permission?
To what?
Like, if it's a large room and we want to pass it, can we just say, may I pass
No,
it?
you want to get up. You don't have to ask permission.
Yeah, you don't.
Get up and you walk over, and then don't talk while you're walking either. Like, don't start talking.
It's
Yeah.
like a really awkward silence, but yeah.
Yeah, but it's okay. Everyone knows what you're doing.
And then don't talk again until you sit back down. I think even though it's awkward. Like
Yeah, sometimes people try to like start asking questions while they're standing up. Still, just wait till you sit back down
not
and
good.
like gather your thoughts, and then that way the witness has had a chance to look at it too for a second instead of just like, here it is. What is this? And they're like, I haven't even looked at it yet.
Yeah, and then yeah, what's up?
So should we be giving them, like, should we be giving evidence for each time we have evidence, or could we just give all the evidence that we're using, like, one time? We're not gonna keep getting that.
Yeah, so you should get up every time you do it. But if the document's already in evidence, you don't have to then get up and give it to opposing counsel again or give it to the arbiter. You could just give it to your witness. And you could even just slide it over and have the arbiter give it to your witness if that's the case. But when you're entering in evidence for the first time, every single time, just get up and do it. Yeah.
The reason, go ahead. The reason you don't want to do it all at once is because you haven't had any chance to explain what any of the evidence is. So like, if I'm the arbiter, I'm getting a huge packet of like mismatched contract agreements, and I don't know what it is. It's way better for me if someone's like, you have the CEO and you're talking about this document, and they're like, oh yeah, this is this contract that I was in the meeting about, and I know that because I signed it, and then I get a copy of it. I'm like, oh yeah, this looks like a contract from the meeting, and like if I have a whole stack, I'm never gonna look at them again. You want me to look at it, right? Like you're giving it to me, so it's just to break it up.
Yeah, and you also you don't want to run the risk of giving them a whole packet and then something being objected to and just getting kept out, and then they have something that's not in evidence. You just don't want to run that risk. Yeah, what's up?
Is there an order as to who you hand it to first?
No, I think you should hand it to the witness before you enter it into evidence, because you're going to be questioning the witness. You could also ask the arbiter if they want a copy at that time, but you could also admit it after handing it to the witness and then give it to the arbiter and give it to opposing counsel. You can do it before or after, but make sure the witness has it, obviously, before.
And this is a good time to remind you to not have any notes or highlighting or sticky notes on the things that you try to enter into evidence or the things that you show other witnesses or opposing counsel. We've seen witnesses be handed something from their counsel on direct examination that has like highlights of like things that they should look for, and that's not okay because that's coaching your witness.
Yes.
So even if you want to call out, like, do a certain thing in a witness's testimony, and we're submitting, like, the testimony, we can highlight this
Yeah, so I was going to get into that, but so you guys aren't going to be the actual testimony of the witnesses, the actual deposition summaries or transcripts. Those are not evidence. You're not going to be bringing them in as evidence.
I was just wondering if we could snip them if, like, the opposing witness on the cross-examination was, like, lying.
That's
So
impeachment.
we're going to get to that. You're
Yeah.
never going to actually admit it, but you're going to be able to show it to the witness and call them out for lying. Also, the witnesses cannot bring any notes with them up there, so like they cannot have a copy of the direct or the questions and stuff like that. Okay. And then lastly, like I said, make sure that evidence is strategically placed in the direct. You don't want to end the direct off on a piece of evidence, just like enter it in and then say no further questions. You don't really want to start off a direct with bringing a piece of evidence in. You want to make it tie through the story and make really the direct flow the whole time. So just make sure it's placed strategically and at the right time. So making objections, y'all got a list. I think there are about 10 or 11 objections on there. Essentially, the number one thing when making objections is don't be afraid. Speak up. If there is a question that you think is objectionable, say objection, Madam Arbiter, relevance, or objection, speculation, or objection, argumentative. Speak up. Otherwise, once the next question is asked, you missed your chance. So speak up when it's asked. So like I said, it's timely objection. State the foundation for it. So whether it's relevance, argumentative, whatever it is, you guys are limited to those 11 or 12 objections.
If you look up on the internet, like objections, you will find like exponentially more than what's on that list, and you're not allowed to use any that are not on that list. So if you look things up on the internet, like you watch videos or something, make sure that you're only looking at the ones that are on that list, because there's like a million more you could make, but we're trying to limit it so that it's manageable.
Yeah, and if you guys go up against a team that makes an objection that's not on the list, feel free to tell the arbiter and just say, Your Honor or Madam Arbiter, this objection is not within our sanctioned list or whatever, and then they should overrule it immediately. Yeah, what's up?
During the pretrial, can we give the arbiter a list of the objections?
They should have it.
I think they'll have it.
And we're going to give it to the judges in training.
Yeah, so
they'll know.
and they'll know. Yeah. Also, plan for these objections ahead of time a little bit. I know it's not easy, but like there are some things that you know every time that like you might want to object just to like because it's a bad fact for you and you just want to break up the flow of a direct, for example. So like for example, when you're talking about a misrepresentation with Ari, how come she didn't change the photos when she realized there was storm damage? You might want to just object to that just cause. Just to break up the direct, just to say that's speculation, or that's even if it's not exactly it, just to break it up, just to break up the flow, to put the other person off guard a little bit. I could go through, if you guys have any questions about the actual objections, I know the list that we sent out had some examples, and I think you guys are going to get another list soon with more examples of the objections. But if you guys have any questions about the specific objection, or if you want to see it in action later when we do our direct and cross, let me know and we can do that just to show you an example. But objections are important. You guys are getting graded on them. I think that's a separate 10-point category just for objections. Also, just as a general tip, if you're the one objecting, only one person is objecting per team when there's a direct or a cross going. So both Ariel and I can't object to the same direct or the same cross. Also, you shouldn't be objecting to openings or closings. Those are usually just as in real life you might, but in this closed setting you shouldn't because it just looks bad on you professionally.
Also, real quick, don't object during openings and closings.
Yeah.
You didn't know that because my closing got objected to.
Yeah.
Yeah, and
Yeah.
like whatever objection you were gonna say, you can usually just make it in an argument, right? So if you think that something was speculation in your own next opportunity to speak, so if it was an opening in the next opening, so if the claimant had something objectionable like speculation near the respondent, without objecting to it, you could just say, like, they said they were gonna prove this, that's highly speculative, and you'll see throughout the rest of this arbitration that we have witnesses who show that that's not true, right? Like you can make the argument without objecting to it formally.
Yeah, and then in general, don't object too much, but also don't object at all. So you want to object at least once or twice during each direct and cross, unless, for example, the cross is 2 or 3 questions. Then obviously everyone understands you can object. But if it's a long enough direct or a long enough cross, you should be objecting, and you also shouldn't object to every single question because then it makes you look bad, and then your objection score could be docked.
Yeah. So find a balance.
Yeah. So So next we're going to talk about crosses. Are you going to do this or am I going to do it? I'll do this. So crosses are essentially the opposite of directs. When Ariel was talking, when she was presenting, she told you guys that in a direct, you're more asking open-ended questions. The witness is the star. Well, in a cross, you're the star. You're the one that wants to ask the closed-ended questions. Instead of asking what day was the contract signed, you should say the contract was signed on April 15th, correct? You're essentially leading the witness throughout the cross. You want the witness to agree to everything you're going to say. When you're planning a cross, you want to have, the way I like to do it is have buckets, like theoretical buckets of like 3 or 4 or 5 main points that you want to get out on that witness. And those are non-negotiables. So for example, if you're crossing Ari, you want to get out that she didn't change the pictures. That's a non-negotiable. And you want to frame that and you want to have 3 or 4 questions just for that. A cross in general shouldn't be longer than 15 to 20 questions. And that's on the lengthy end. You want quicker crosses, you want to get in and get out, because oftentimes you could hurt yourself on cross a lot more than you can hurt the witness or the other side. Because you could screw up, you could let the witness talk, and that won't look good. So on cross, never ask an open-ended question. Never allow the witness to kind of get an answer in. But at the same time, don't cut the witness off. So if you say the contract was signed on April 15th, correct, and the witness goes, yes, blah, 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 blah. Let the witness talk and then go back to your original question and be like, so is that a yes to my question that the contract was signed on April 15th? And then that way your question gets across twice, the arbiter hears it twice, and the witness is back to a yes or no. You always want to get that yes or no out. So like I said, redirect the witness back to the question if necessary. Also, I think the number one thing during a cross is to listen to what the witness is saying. Oftentimes, the best thing for a cross-examiner is to have a chatty witness, because the chatty witness is going to talk about a lot of things that's going to hurt the witness, and use it. So if the witness says something that's really crazy and outlandish, make sure you go after it, because I bet the arbiters are going to be listening to it, so they're going to want to know more about it too. So make sure you're listening to the witness, and you're not just staying on script the whole time. Also, use the whatever's coming out on cross in your closing, and that's kind of how you guys can frame the other witnesses that you guys aren't directing in your closing argument, because you can essentially put already, like in your little outlines, what you want to get out of those witnesses, and if you do an effective cross, you will get it out, especially because you guys have such a close pool of objections. So a cross happens right after the direct. So once the directing attorney says no further questions, Your Honor, or Madam Arbiter, the arbiter is going to turn to the other side and ask for a cross. Like I said, close-ended questions. You always want a simple yes or no. Also, these questions should not be long. They should not be, like a rule of thumb, not longer than like 12 words if possible per question. Something short, something quick, something easy to understand. And you'll see that when we do our directs and crosses. So the way I kind of like to do crosses, at the beginning, you should always start and you should be nice. You should be the witness's friend. So something I like to do with every witness I cross is kind of start with the witness's background. Even if the witness talked about that he was a CEO in his past days and he owns this company, I kind of like to reiterate it at the beginning of the cross and kind of just say, so we heard a little bit about your background, but I want to talk a little bit about how you were a CEO. So is it correct that you were the CEO of Elux? Yes. Or sorry, it's correct that you were the CEO of Elux. Yes. And you were there for 5 years. Correct. And then go into the more damning stuff. You want to be the witness's friend before the witness's enemy. If you start off at pounding the witness at the beginning, you're going to get the witness very hostile early on and very sassy early on, and then the witness can hurt you. So be careful with that. Also, practice when you guys are doing your scrimmages and just with your partner and your witnesses. Practice having the witness kind of just say something that's wrong on the stand or lie on the stand, and practice going through an impeachment. Practice if the witness says something that's objectionable, or something I like to do with Ariel, we object to every question, sometimes during as a drill. So if I'm doing a cross, Ariel will object to every single question I ask and just make up objections just to see how I'd respond to them. Because you never know what's going to get thrown out in the real thing. So that's just a quick and easy thing that you can do to help you. Avoid the one question to many. This is more of So the point of a cross isn't necessarily to get, like on TV you guys see someone getting crossed and like they get the yes, I'm guilty, or yes, I committed that murder out on the stand. You don't want that because you're never going to get that in a mock trial or in an arbitration. You just aren't. So you never want to ask that last question. So for example, if you're crossing on the fact that Ari misrepresented the photos, you want to get out the fact that those photos were never changed. But you never want to go and say the last question being like, and you misrepresented that, correct? Because as a witness, the witness could just be like, no, I didn't misrepresent it. And then everything you just did gets undone. So you never want to ask that last question that essentially is like the winning question. Because what you can do is you can make that an inference and that assumption on closing. And even if she didn't say that she misrepresented it, you can say that she misrepresented it in closing. So make sure to do that. Also, make sure to look at, or rather listen to the direct exam and to really harp on the points that hurt you the most during the direct. Sometimes the direct won't even bring up bad points that you had that you're going to cross the witness on, so stay away. Sometimes it's not worth it. Really react to the way the direct is going and kind of model your cross off on that, so add or subtract questions based on how the direct goes. And then the last thing is you can cross on really anything. You're not really limited to anything except the facts in the prompt. Don't make up new facts, especially don't have your witnesses make up new facts. They're stuck to the prompt, and make sure that they don't make anything new up. But you can cross on what the witness did not hear, did not see, did not do, in addition to what the witness did see, hear, or do. And if you have any questions, you can ask.
Go ahead.
Are you allowed to introduce evidence on a cross or only on direct?
You are allowed on cross, but it would be different, right? So it would be close-ended. So instead of asking, what have I just handed you, or do you know what this is? You could say something like, this is the cancellation policy that we've been talking about, right? And you know this because you've seen this before. And then you could enter it in. It just reframe the question to make it pointed and closed-ended.
Yeah.
All right. Cool.
All right. So we're going to now talk about impeachment and refreshing recollection. So impeachment is when the witness contradicts something that you have a reason to believe is not true. So what are there in this fact pattern? Deposition statements or affidavits? Okay, so you have deposition summaries, right? So if in the deposition summary it says the sky was blue on that day, and you're talking to the witness, let's say it's even your own witness, right? So I'm like, Aaron, what color was the sky on April 1st? Or what color was the sky on the day we're talking about?
Green.
And that's my witness, right? And he said something that I need to undo because it's important to the whole story. So I might say something like, are you sure that that's what the sky looked like?
Yeah, I'm pretty sure it was green.
So then, now I'm freaking out, right? What do I do? So I might say something along the lines of, do you remember making a deposition summary? Do you remember taking a deposition?
I do.
And if you saw that, you would recognize it?
Yeah, probably.
So then I'm going to get my deposition statement for my own witness, and I'm going to give it to Aaron, and I'm going to give it to opposing counsel, and I'm going to ask the arbiters if they want one. So Aaron now has my statement, or his statement. And then I'm going to say, Aaron, will you go ahead and look over the statement for a minute?
Yes.
Okay. And then I'm going to figure out where in the document it says the sky is blue. So then I say, Aaron, could you go to page 3? Can you read what it says on line 21?
Oh, you're right. The sky was blue, not green.
Okay. So then I'm going to take the paper back from everybody, and then I'm going to ask, so Aaron, what color was the sky on that day?
It was blue.
So that's if it's your own witness. And again, you want to be as nice as possible about it. You're not trying to catch them in a gotcha because, they forgot. And maybe Aaron would have some reason why he forgot. As a witness, you might want to encourage your witness to do that. But it's not so bad, right? It doesn't look so bad for your side. It just looks like Aaron forgot something, but he shouldn't forget something super big. A smaller thing like a date, sometimes your witness might say 2018 instead of 2019, and you might just want to clarify that for the record. So that's one way to do it. That's what impeachment is. But you might also want to impeach on cross-examination, like somebody asked a question about. If there's a very important fact, like the light was red, and this witness now says, no, the light was green that day. It was green, so I went through the light. you definitely need to correct that. So you still want to be nice about it, like we were talking about how arbitration is very professional and collegial, but it kind of goes the same way. Do you remember making a deposition summary? Yes. You'd recognize it if I showed it to you. Yes. And then you would give it to them, directing your attention to lines 21 and 22. It says that the light was green or was red on that day. And if that's what it says, they don't have really an option but to say, yes, actually it was green. So that's what you have to do if there's a fact that's being like contradicted. But you only want to do this if it's like something important, right? So people sometimes impeach over like what color shirt they were wearing that day. If that's not important, please don't impeach over that. Don't impeach about the weather. It's really a judgment call. It takes a lot of time to impeach. So only do it if it's a really important fact for your side, like the light was red instead of green.
Yeah, don't impeach on a witness's background. That's usually like something that you shouldn't.
Right, so if my statement says I have a Juris Doctorate from Harvard, and then on the stand I say I have a JSD from Harvard, please do not impeach me on that. It doesn't show anything to anybody. It just wastes a lot of time. Nobody looks bad or worse. It kind of just evens out.
But it's also strategic, right? Because like if Ryan, for example, says he's had 30 years of experience in the management business,
Very
but he only
different.
has 5, that might be important if you want to get to the point that he's not experienced.
Right.
But just be very cognizant of what you impeach.
Mm-hmm.
So then we do like an objection if their points are wrong. We object to that's wrong, but that's not right. Like his side doesn't go in and do an impeachment.
Yeah, so I don't think you need to, unless it really hurts you. You can't object in general on like an improper impeachment because that's not an objection in your.
You would have to like impeach them yourself
Correct.
on cross-examination.
Like.
So you'd have to ask them the
Yeah.
same question, and then if they give the same answer that they gave the other counsel, then you would do what we just talked about. But there's no objection for you to use. You just would need to clarify it by impeaching them. Yeah. Or if that document is in evidence, right, you could just skip it and in closing be like, Madam Arbiter, please go to this page of the document where it says that he only has 5 years of experience, and that's what he wrote down, and you could just, well, no, you can't do that because it's not in evidence, but if it's a document that is in evidence, then you can, if it's like the date of the contract kind of thing, you could do it in closing. But if it's material, you're gonna impeach them. If it's not super important, you're not going to.
Yeah, as a rule of thumb, don't impeach unless you necessarily have to.
Unless it's like
Yeah, 'cause
really.
it's a very confusing process, especially if the witness is not a very well trained witness. The witness can kind of like wiggle out of it, and you might not know what to do because you guys haven't done this before. So unless you absolutely have to, I would just stay away from impeachment. It's not gonna. It could only really add points to you if you do it really well, but it could also hurt you really badly if you do it very poorly and the witness wiggles out. So like it's a very like risk reward calculation, and I don't know if I personally would do it unless it would make or break my case.
The impeachment is necessary in case someone like it's literally like, did someone run a red light and now they're saying that the light was green, right? Like that is the fact of the case that you have to establish. That's a worthy impeachment cause. Other things, it's hard to imagine why they would be so important. So I would just be careful about it. Maybe talk to your coach about what would be like impeachable. Maybe come up with like a little list beforehand. And like if it's not on that list, I'm not going to do it. And practice it once is what I would also recommend if you think that you might have to use it. All right. And then when you impeach somebody, by the way, that document doesn't go into evidence. So nowhere in that exchange that I had with Aaron did I ever say, Madam Arbiters, this is now into evidence. You're just having them look at it and see that what they said before is different than what they're saying now. It doesn't go into the record. What goes into the record is that the witness is now like, oh, wait, sorry, I forgot. The sky was actually blue that day. So now we're all accepting that that is the new fact that we're going with. You've clarified it. You don't need that document because that document has a lot of other things, and it would be really confusing if I got one deposition summary as an arbiter to read after and I didn't have anybody else's just because somebody was impeached. Yeah.
If a witness is impeached, would that suggest their testimony is unreliable? Or?
It does, right? That's the impression that you're giving. But again, if it's your own witness, right, like you'd have to fix the fact, but you still, that's why you want to be nice about it on both sides, but it does impress that. And I think the next slide talks about how you want to remind the arbiter during closing argument that the witness was impeached. I think it's a great thing to remind people, and exactly what we talked about. Mr. Witness came up here and testified, said he had all these years of experience, said that he remembered being in the room on the meeting of the day in question. But in fact, ladies and gentlemen, he told you conflicting testimony. He first said that the sky was green, and then after being reminded, actually came back and said the sky was blue. We might not be able to trust his testimony as being so reliable. You could literally do it just like that.
If they
Questions?
say something that conflicts with their same side witness, the other witness on their team, if it conflicts, can you bring that up before the other person testifies, or do you bring it up with the other person?
So you could bring it up with the other person. So for example, the call between Ryan and Alex, one says something was heard, the other says something wasn't. You can, when you're crossing Ryan, for example, you can say, now you were here when Alex testified, correct? And you heard her say that she never heard anything on a call, correct? And you guys are both under oath, correct? So is it still your testimony today that that you never told Alex any of this, or something like that? You could imply that they lied, even if the witness doesn't answer the way you want to. You could still imply it, but
Right.
Don't do it with another person's affidavit.
But yeah, otherwise the witness only knows what the witness knows. Only the attorneys know the whole scope of things.
Yeah.
So if there's a random other fact that's only in one person's affidavit, really that person's affidavit really has the knowledge to speak about it.
Yeah, going to what happens in arbitration, aren't all of the witnesses sequestered?
No, they could be in the room. I think it depends on the arbiter.
Constructively.
Constructively,
They could sit there, but
they could sit there.
So
But
there's no witness that sits
Well,
throughout the entire trial.
no, but the client does. The client does. Your defendant or your claimant could sit there.
can also sit in the room.
Yeah, and the witnesses could also sit in the room.
They can sit in the room.
But in a real arbitration, your actual client would sit in there with you. So Ryan would sit in there, and then Alex would sit in
So
there.
they can testify about things that happen.
Likely, yeah.
Okay.
And that's something that you can clarify during housekeeping too. You can say, Madam Arbiter, we understand that the witnesses are constructively sequestered, but may these two witnesses not be for the purposes because they're the clients or something like that.
Also,
Yeah.
real quick, if you are a claimant, when you're done with your witnesses, you can ask the arbiter if your witnesses can be excused.
Excused,
Your witnesses can leave once you're done. They don't have to stay till the end. If you're a respondent, we were a respondent and we had our witnesses come if we were at 9, we had them come at 9:30. I wouldn't do past that, but they could come a little bit later because you can do all of opening and all of claimant stuff, and then in your recess, you can go get them.
Yeah, but if your witnesses are allowed to sit there the whole time, the judge allows it and they're just working on things, they're not allowed to use, except for the the claimant and the respondent, that's the client, they're not allowed to be and you know what, I was sitting here and I heard Ryan talking and it was an absolute lie, and they can't use that now as part of their testimony, because sometimes you have really smart friends who hear that and they know, you've trained them, this is what we're supposed to get out of you, this is what the case is, this is how we need to win, but that would be not allowed. So then sometimes when you impeach a witness, they try, if it's your opposing witness, so if it's not my own client, if it's the person on cross-examination, they try to start to explain away why they were wrong. Just don't let them, right? You ask them the question. So it is true that the sky was blue on this day. Yes, move on to your next question. Don't let them start talking because you didn't ask a question after that, right? You asked for a yes or no. Don't ask what is the truth, because then they'll just reclaim. Sometimes people like to ask this. Don't do that, because then they'll just be yeah, I was just really wrong the first time. I'm sorry. I'm very forgetful. And then it doesn't look that bad anymore, right? Okay. So this is a little trickier. This is impeachment by omission. So before it was impeachment by something contradictory, right? The witness was saying something different than what they had said before, and you had documentation of it. Impeachment by omission is the witness isn't lying, but they're making something up that's super helpful to their side that wasn't there before. So it's the same process, except for the question you're asking isn't you said this before, now you said this. The question is when did you ever say this before? How was I ever on notice that this argument was going to come up? So you would give them their deposition summary, and you would say, No, if it's on cross-examination, you would say, nowhere in this deposition summary does it say that the sky was purple, right? And they had a chance to look through it, and they would say no. But again, this is like a big judgment call. Only do it if the new thing that they make up is like super, super damaging to your side. If it's like a different bachelor's degree, if it's like something irrelevant, don't impeach them by omission. It's the same process, but this one's a little trickier, as you could imagine, because the line between like what's made up and what's super important to your case is a little more wishy-washy. So if they make up something new and you've never heard of it and it's like a gold-winning argument, you can go ahead and impeach by omission. And you're never, by the way, you're never like, oh, I'm about to impeach you. I don't know, sometimes I feel like people try to say that. You impeach just by the way that you ask questions. So you're just like, okay, you just said that the sky was blue. Are you sure that's what you're saying today? Yes. Okay, well, I'm showing you your deposition summary. Yes, this is my deposition summary. Nowhere in this deposition summary does it say that the sky was blue. And then they would read it and they would say, no, you're right, it doesn't. And then you move on. You've made your point. It wasn't in the deposition. So this one's, again, a little trickier. It's just like a safeguard in case somebody kind of goes a little crazy and makes something up, because it would be really easy and give them a winning argument for their side. Okay. So the alternative to impeachment is if your witness forgets like something that they need to remember and you want to refresh their recollection. So the example before with Aaron, who was my own witness on direct, he didn't forget. He was like, no, the sky was green. Like, I remember. But that's different from Aaron. What color, what do you remember about the sky that day?
I don't know.
So he's just forgetting, right? Like maybe he didn't memorize it. Maybe I'm asking a question in a different way than I had practiced. So what you can do is you could say, Aaron, is there anything that would help refresh your recollection?
Yes.
And what would help you?
Probably my deposition testimony.
So then I would go get the deposition testimony, and I would, again, opposing counsel, do you want to copy? Arbiters, do you want to copy? Aaron, here's your copy. Aaron, go ahead and take a look at your deposition summary, and as soon as you've found what you're looking for, go ahead and tell me when you're done. You're done. And then you have to take the document back, because it's not fair that Aaron gets to sit there for like the rest of the time with his document, so take it back. So Aaron, what do you remember about the color of the sky that day?
It was actually blue.
Okay, great. And then I would continue going on with the rest of my questions. So sometimes witnesses forget things, right? So that's what this is for. And it's just a little way to help you do that. And you should coach your witness that if they forget, they shouldn't like try to make stuff up or like move to the next question. They should just say, I don't remember. And it's totally fine. You'll ask them what would help them remember. You give them their thing and they'll move on. Sometimes people like freak out and then start making up those like material facts that are really good for their side. And then there's the like impeachment problem. So just tell them to say like, I don't remember. And it doesn't look, I mean, if you do it once or twice in a round, it looks totally fine. Yes.
Do you have to also give it to like the arbiter, like the deposition, or can you just give it to them?
So you would ask them. So I might have gone a little fast, but I said you definitely have to give it to opposing counsel. And the reason why you're giving it to them as opposed to like, let's say they have a copy of it, is because in theory you could have like redid the whole deposition testimony and like exited, like whited out all of the bad parts and like just had the good parts, and like that's what you're giving him. Or you could have like written some notes on it, right? So that's why you have to show them the copy that you're about to give the witness. And then you could just ask, this is a personal preference thing for the arbiters. Madam Arbiter, would you like a copy? They might want to follow along line by line. They might not care and just want to see if you can do it or not. So just ask them. And this is something you can ask in housekeeping. If I'm presenting a document into evidence or if I'm impeaching a witness, would you like to see that document before or after I've completed whatever I'm doing?
Yeah. And remember that during housekeeping, the claimants are going to give the full packet likely to the arbiter, including all the witness testimony. So you could also just refer the arbiter, just say, Madam Arbiter, referring you to the testimony or the deposition of Alex and Elia. Yeah.
So we don't need like 10 copies of everything to keep handing people. We can.
No, stick to 4. One for yourself, one for the witness, one for opposing counsel, and one for the arbiters.
Yeah.
Yeah.
My question was about how many copies.
Gotcha.
Yeah, I think 4 is a great number. Yeah, 4 clean copies. Cool. So we've done a few examples, which is fine, but it's the same example. Okay, so the next thing we have is a little demonstration. Do you guys have questions that you have not asked yet that you want to ask now? Yes.
So can we, like, when we're cross-examining or direct examining, can we say things like good morning?
Yeah, no, and those little like niceties are really important, I think, to the feel of the room. So I would definitely say good morning. You can tell the witness who you are, because if they're like constructively sequestered, you could say, hi, my name is Ariel Stevenson. I represent the claimant in this case, and I just have some questions for you about the contract, like whatever, or I just have some questions for you today. And you can go ahead and start going. So those little things are stylistic. Some people like doing that and some people don't. But I would encourage making it as collegial as possible. Yeah. One more question and then we'll take the rest of them after the demonstration so that people who want to leave can leave. Yeah. Cool. All right, so we're gonna do a little demonstration. Oh, we're gonna have to project. Okay.
Okay. So I'm going to be directing my client Taylor Swift in a contract dispute or a copyright dispute where Kanye West stole an album cover that they designed together, okay? So good afternoon or good evening. Could you please introduce yourself to the arbiters?
Hi, my name is Taylor Swift.
Now, Ms. Swift, what do you do for a living?
I'm a musician and like a performer, and I've been doing that for many years now.
About how many years would you say?
Since I was a little girl, maybe like 8, but probably like 10 years professionally if I had to give, a more exact number.
Now, Ms. Swift, what kind of music do you make?
I started off doing country, but I sort of really developed a liking for pop. So I would say mostly pop, but I kind of had that country background.
Now, I want to move on and talk a little bit about why we're here today. Do you know the respondent, Mr. West?
I do know Mr. West. We worked on some songs together, a whole album actually, and we sort of had a disagreement about it.
Now, what kind of disagreement was this?
Well, we designed an album cover that was mostly my idea, and instead of us using it for our joint album, Kanye took the album for himself and used it for his latest album.
Now, I want to talk a little bit about the album cover in particular. What about the album cover did you design?
So I came up with the idea of it. The idea was for it to be like a sunset on the beach. And, Kanye's kind of into really dark things and I'm more into nice and bright. So this was kind of like the darkness setting in on the light. And I thought it was a really cool idea. So I came up with the actual idea of it.
Now, Ms. Swift, would you recognize a draft of the album cover if I showed it to you?
Yes, I would.
So now I'm going to be entering in an exhibit. Pretend this is the album cover because we don't have a fake album cover or whatever. So Madam Arbiter, let the record reflect that I'm showing the witness what was pre-marked as Claimants 1, the album cover. What have I just given you, Ms. Swift?
So this is a draft of the album cover that I created for the album that Kanye and I were thinking about producing.
Madam Arbiter, at this time, I would like to enter into evidence Claimants Exhibit 1. It's into evidence. That's really it. And then if there's an objection, opposing counsel will stand up, or not stand up, sit down and say object. Objection.
You ask anything wrong, object.
Yeah. Okay. So now, is it possible that anyone else created that album cover?
So created is a difficult concept, right? I definitely.
So that was a possible speculation objection that was missed. So is it possible? I'm speculating that there could have been other possibilities. So that's a possible speculation objection. So I want to talk a little bit about that album cover. Show the arbiter, what part did you create?
So again, I came up with the whole idea. This picture clearly reflects a sunset on the beach. There's clearly a darker part of the top half of the album where the sun is getting darker and setting, and then the bottom half is where the light still reflects and it's obviously brighter.
Now, what part did Kanye or Mr. West create?
I feel like another speculation.
Yeah.
Depending. But So Kanye picked like the colors. He was really into that. He thinks he has like a lot of artistic design capabilities. So he picked the color, and then he picked like the filter to put over the color. But again, like the whole idea was really mine.
Now it's true that you didn't pick the filters, correct?
No,
Okay, so that's a leading objection on direct. I shouldn't be leading the witness to the answer. Okay. So now, why don't you tell me why you didn't pick the filter?
Still a little leading. So I just don't have as much like design and color scheme capability. Kanye, does a lot of clothing, and he's really good at that. So I was more about like the initial inception idea.
Okay. Now, did you ever copy anything that Kanye did?
No.
Did you ever take Kanye's idea?
No.
Did you ever have sex with Kanye? That's a relevance objection. All right, that's really obvious, but I mean, there's going to be a little less nuanced thing. All right, now tell the arbiters